was one of the most, I would say, meaty chapters of this book. It covered, again, both the types of employment. We've gone over the wage and hour laws and layoff requirements. We've gone over the various leave policies and benefits relating to employee leave. We talked about occupational health and safety. We've talked about the income security benefits, including Social Security benefits, right? What other income security benefits are there? Income and health benefits, what other?
Medicare.
Medicare, right? We also talked about pensions. What type of pension laws are there? What are the pension laws that protect pensions? Remember me? What was the law?
The private pension plan.
Remember ERISA, right?
Oh, yeah.
And then we talked about medical insurance. What are the two laws that govern employees' medical insurance? Well, there are three. We talked about one, which was related to people who are, again, Medicare, we said, is available for people who are what?
Over 65.
65, right? But what are the other two medical benefits that are guaranteed by law? COBRA, right? And the other one is what? The Affordable Care Act, all right? Then we discussed the issues relating to, we didn't actually talk about privacy rights. We may come back to that. But last class we dealt with immigration. What is the law, the premier law, that principal law that deals with the ability for a worker to work or a person to work in the United States if they are not a citizen or a legal resident of this country. What is the law that we discussed before?
The Immigration Act.
What is it called?
Immigration Reform Control Act.
Immigration Reform Control Act, right? Immigration Reform and Control Act, right? And we talked about what was the primary document that companies and employers have to use in order to verify a person's immigration status or citizenship.
I-9.
The I-9 form. And what is the requirement in terms of the I-9 form if a person completes that form incorrectly? What is the requirement for the employer?
Fine.
What is the requirement for the employer? The employer's obligation in terms of the form is to do what? There are two parties who have obligations, right? What's the obligation of the employer?
Check form accuracy. If you verify the document.
So it's a verification form, remember?
Mm-hmm.
It's a verification of what?
Eligibility for employment.
Exactly.
P15.
Thank you. And so, again, the first requirement is to verify. And if he does not, or she or the company does not verify the form, what are the possible penalties that they're subjected to?
Fine.
And what kind of action did we discuss that could be taken? What are the two types of actions that can be taken? Administrative action. And administrative action is what, Ms. Murray?
Isn't that just like dealing with firing and stuff.
What's the difference? What is the action that can be taken against the employee?
Administrative need a law
So what is
judge.
the action that can be taken against the employee? What is the action that can be taken against the employee?
Is it
Well, there's two types of actions. One that would be taken against the employer.
Legal action.
Legal action can be taken against who?
the employee?
Employee.
And what's the difference, Mr. Muslim, between the legal action and the administrative action?
Administrative is less serious, I guess.
Yeah.
What's the key component?
It's not in court.
It's not court.
What is it? So it's not in court. What is it? Who is it before?
A judge.
Yeah.
What?
Administrative judge.
Administrative law judge. Exactly. Those are the key distinctions that we discussed between the types of actions. And we discussed that we will be going a little bit further into the issues of administrative legal proceedings versus legal proceedings before a court later in the chapter. But we talked about the various visas. What is the key visa that people are seeking? There's two visas that we discussed in order to work. What is it called?
Work visa.
What specifically is it called?
H-1B.
The one, not that one. What's the other one? The first one, the one that everybody wants.
The I.
The what?
The I-551.
It's right there. What is it
Green
called?
card. A green card.
The alien registration.
Exactly. What is the exact legal name of this? What is it?
I-551.
It's the what?
I-551.
The I-551 what?
Alien registration receipt.
Alien registration receipt, also known as a what?
Green card.
Green card. Come on. This is right here in the book, right? This is reviewing. And the other one is called the what? The what?
H-1B.
H-1B. And what is it that you have to show? What does the employer have to show in order for him to hire somebody under the H-1B visa program?
That there's no that's qualified.
What's that?
No other American citizens qualify for the job.
Right. They have to show that, first of all, that the employee is a what? He's in a
Qualified
what?
for the job.
What type of occupation? Specialty occupation, right?
Specialty.
And that he has what? He or she has what?
Knowledge to obtain.
Highly specialized knowledge, right?
Mm-hmm.
And he has what type of certification?
A bachelor's or higher degree.
At least a bachelor's or higher degree, right?
Mm-hmm.
And they can stay for how many years?
3 to 6 years.
Right. Okay? And if you leave that person, that employer, what has to happen? If the employee leaves, what happens? If the employee leaves, what happens? Come on, people. It's right there. If the employee leaves, what happens? Right, the permit is terminated. So again, the permit is really for the employer. The employer applies for it on behalf of his employee. If that employee leaves, then he or she becomes, again, a person considered out of status. All right? We also talked about and so there's some other visas that are out there. For example, the H-2 visa is for agricultural workers or seasonal workers. And there are a lot of seasonal workers here. Even we consider seasonal workers mainly in the Southwest and the South, but there are seasonal workers here in the state of Maryland. particularly in the crab industry. You know, I understand they import hundreds of women from Latin America in particular to work in crab processing operations. Very, you know, tedious and somewhat dangerous operations. But these are things happening right here. And so some of you all might be, you know, called upon to administer and even hire people in these type of positions. So you need to know about those types of things, right? There are some, again, L visas, which require managers and executives, or allow companies, managers and executives to get in. There are also these E visas. E visas are, again, visas that allow people to come in the country in exchange for them making investments into the United States. So those are the things that you need to know. Also, in the last class, we talked about the fact that some states pass laws that go into the area of immigration, and what generally has been the court's position on those. Huh? What is generally is the court's position on state laws, state immigration laws? Remember we talked about the Arizona court, the Arizona case? Right. Immigration laws are governed by the federal government, but I'm asking what has been the court's position on state laws? Some state laws that are not going to be allowed, and some state laws which may be allowed. What's the difference? What is the difference? It's right there in the book. Again, if this continues to happen, I'm going to have to start doing like daily pop-up quizzes. All right. I'm asking you to read for me what is in the book. I'm just kind of reviewing it before going into this next chapter, or this next part of the chapter.
The Supreme Court does not prohibit states from enacting laws related to immigration, but it does set some limits.
And what are those limits? What is allowable? What type of laws are allowable? States can do what?
Require individuals to show documentation of their immigration status to law enforcement when requested to do so during a lawful stop for other reasons.
What cannot they do?
They cannot pass law that
they're prohibited from making it a crime for immigrants not to carry their registration documents, or for those without work permits to seek employment.
Exactly. Right? And also, they can't do what?
Authorize law enforcement to arrest anyone based solely on a reasonable suspicion that the person is in the country illegally.
And they were doing that in what state?
Arizona.
Arizona, right? What's the famous sheriff? Huh? Does anybody remember that?
I don't.
Sheriff Joe Arpaio. Remember that? The big sheriff hat going around picking up people based upon, again, what they look like. Thank you. So you getting stopped, sir, ma'am, you look like you don't belong in the country. Where are your documents? Right? On that basis alone, they were stopped. Not because of a headlight broken or some other offense. So again, these are the things that, again, in the last class, I said that all that type of activity had been stopped by the court, but the courts did allow, again, law enforcement to arrest someone based upon a reasonable suspicion. I'm sorry, they don't allow somebody to arrest someone based upon a reasonable suspicion, but they do allow law enforcement to ask for documentation of the immigration status, right, after a lawful stop for another reason. So that's the distinction. What I want to go into one quick thing, and that's something that we probably all, as people here in this era in particular, are going to be confronted with, and that is the issue of employee rights in the context of your privacy. So you get hired, and first thing they do, they give you all these forms to sign, and they give you an email account. And in that context, you begin using email account and also using the Wi-Fi, the internet that is provided. And what happens if you begin to get these emails from your buddies that have either crazy types of pictures or outlandish jokes, and then somebody calls you into the office and says that you were exchanging emails and sending emails between people both in the company and outside the company. And they say that they have been checking and noticing that you've been sending these emails. What are your rights, Mr. Tucker? What are your rights in that case? Mr. Tucker, what are your rights? Mr. Tucker?
Yeah.
What are your rights?
I don't know.
What are your rights, Mr. Willis? What are your rights in that type of situation? You have now been called in to answer for Mr. Willis. What are your rights? You've been called in to the HR office because you've been sending around lewd and perhaps even pornographic material using your company email account and internet. And they say that you again are subjected to possibly firing because they've noticed that you've been doing this.
Well, I mean, honestly, I feel like you don't really have any rights because you shouldn't be the company.
I'm asking you based upon what's in the book, not based upon your feelings. Let me ask, Miss Hall, Sydney Hall, tell me, what are your rights? I'm in the chapter 27. That's what we're going over.
Yes, thank you. What?
How about you, Miss Hodge? Tell me about it. You work at a hotel, right? Miss Hodge. So if you're at the hotel and they call you in because, in late nights, trying to keep yourself up, you've been watching, some crazy video vines or memes that have perhaps pornographic or material or maybe even insulting material. They say that they've caught you. What are your rights?
Okay.
Either I can do it right because they should have had the web.
It's the Electronic Communication Privacy Act.
And what does the Electronic Communication Privacy Act allow or prohibit, Mr. Tucker?
It prohibits employers from intercepting an employee's personal electronic communications unless they are made on devices and systems furnished by the employer.
So in the context of Miss Hodge at her hotel, she's a desk manager, trying to keep herself up overnight, and so she's using their computer. So what happens when they say, well, we've been monitoring your communication, we've been monitoring how you're using internet, we've seen you go to XXX.com or Pornhub.com or whatever outlandish websites there are out there. What can they say to Ms. Hodge? Well, I mean, what can Ms. Hodge? Ms. Hodge says, well, you're not able to go and view what I've been doing. That's illegal. What would they say to Ms. Hodge?
Well, they would, I guess they would say is a reasonable exception of privacy. So
She would say that it's legal, but what would they say, Ms. Hodge?
So they can monitor the employees in the workplace.
They can first of all, what she's using it on. Again, where is she using it? What kind of system is she using it? Is it her own? Who's providing that?
Sometimes they should have blocked it off, right?
I'm asking you, what is it the book says, not what you say.
Provided by the company.
It's provided by the company, right?
Mm-hmm.
So if it's provided by the company, then what?
Then it's she's.
Then they have the what?
They got the right.
They have the right to monitor. So again, if you're using your company computer, right, or your company internet, right, then they have the ability to monitor, right? Now, the other exception, Mr. Parks.
I have a question.
Okay, we'll hold it.
Okay.
Ms. Hall, the other question. So let's say if you are using your phone, they didn't provide it to you, it's your phone, but it's their Wi-Fi. What happens then? Can they monitor it?
Yeah.
Why?
It's their Wi-Fi.
It's their Wi-Fi, all right? Mr. Willis. It's your phone, you're not using their Wi-Fi, you're on your own LTE, your own system, you're paying for it, and you're at work, trying to keep yourself up, watching some crazy material, or sending it with your buddies. Can they monitor what you're doing at that time?
That was an issue not be able to.
Why?
If employees have not been informed that their communications are being monitored, they cannot reasonably expect those infractions.
So the question is whether or not if there is a reasonable expectation, right? And what do most employers give people, again, at the beginning of their work? They give you a lot of forms to sign.
Yeah.
And it's possible, particularly in the idea of privacy, that one of those forms that you're going to sign is a form that notifies you that all communications that take place during work is going to be what? Monitored. And if they give you such a form, then would you have a reasonable expectation of privacy at that time? It's likely not. Might be some arguments that you could put forth, but it's likely not. So that's the key thing you want to that you want to be aware of. Let's talk about and so again there are some exceptions. Some exceptions is when again there is a person is a government employee versus whether or not they are private employees. There's another law, as I understand, that happens with respect to government employees, right, versus private employees. That's one thing you want to be aware of. The second question, you guys can have a seat. Let's ask you, Mr. Tucker.
I had a question, ma'am.
Yes, Mr. Parks?
All right, so I think what she was trying to ask you was, it says in the bottom, private employers generally are free to use filtering software to block access to certain websites, such as sites containing sexually explicit images. The First Amendment's protection of free speech prevents only government employers from restraining speech by blocking websites. So I think she was trying to say, if they don't have a blocker up and you do watch it on their Wi-Fi or whatever, can you still get in trouble?
Yeah, absolutely. It says they can, right? It says they're generally free to use filtering systems, but they're not required to do so.
But then it talks about the First Amendment.
Yeah, the First Amendment says that free speech prevents only government employers from restraining speech by blocking websites. That means that government employers cannot block websites, right? The question that we were asking is whether or not if she uses this website for this purpose, would she be subjected to a issue? So that's one thing. I want to the other chapter. I mean, the other part of labor relations we're going to have to get to on the next class. But let's go ahead and go straight to the presentations right now. Each group will have 5 minutes. Actually, I'm going to cut it down to, because this is a more simple one. So we'll give everybody three minutes for this right here. We'll start with team 1. Team 1, come on up.
Need to end this? Team 1 is a document. No, that's team 1. No, that's team 4.
It's the second one.
This one here?
No, next one.
Down right there?
To the left.
That right there?
Mhm.
All right, great. All right, who has the time? Give them, everybody 3 minutes, all right? Tell them what their time is.
Do you want me
Say
still?
so, if it's, they have,
Am I still
after 1
recording?
minute, say 2 minutes left. After 2 minutes, say 1 minute left, like that, okay?
Am I still recording?
Yeah.
Okay.
All right, go ahead.
Good morning, class. My name is Sydney Hall. I'm Justice Mary.
I'm Brian Son, Larry Thomas.
And we did our PowerPoint on filing an EEOC complaint. So, identify the possible laws violated by the employer. Title D2 of the Civil Rights Act of 1964. It is
Title what?
7.
Second?
7.
7. Oh, I thought that was 2. D27. Gotcha, sorry. Title 7 of the Civil Rights Act of 1964. It is illegal to discriminate against someone on the basis of race, color, religion, national origin, or status. It is illegal to retaliate against a person because the person complained about discrimination, filed a charge of discrimination, or participated in an employment discrimination investigation or lawsuit. Employers must reasonably accommodate applicants and employees sincerely held religious practice, unless doing so would impose an undue hardship on operation of the employer's business. 180 calendar days from the day the discrimination took place. If a local agency enforces
Make sure you
a
tell
law
them the time.
that prohibits employment discrimination on the same basis, the deadline is extended to 300 days, 300 calendar days.
Under the Equal Pay Act and time limits, you don't have to file a discrimination charge with the EEOC and can go directly to court and file a lawsuit. The deadline for filing a charge or lawsuit under the EPA is 2 years from the day you received the last discriminatory paycheck. Holidays and weekends are included, but if the deadline falls on a weekend or holiday, the deadline pushes back to the next business day.
So for the EEOC draft, there isn't like a set idea per se. This has a few requirements like your name, address, your information as to how to be contacted, and a brief description as to the situations that happen, including dates and names of names of individuals that the situation were involved. So in our case, we produced a list of complaints as to how it went by based on the sequential method, I guess, represents. And this is what we came up with in regards to our draft.
All right. What was the deadline for the presentation, for the information? So what is the deadline? Well, based upon the facts that were given, what was the deadline?
Submitted within 180 days.
Was the date, You said, did you say 180 days, 300 days? What is it?
No,
It's 180 and then it extends it to 300 days.
Huh?
It's 180 calendar days from the day discrimination took place. If a local agency enforces a law that prohibits employee discrimination on the same basis, the deadline is extended to 300 days.
So again, what was the deadline for this situation?
We didn't get that
What's it?
deadline.
Okay. All right. All right. Thank you. Anybody have any questions? All right, next group.
Good morning. My name is Nate Tucker.
Karim Muslim.
Montrez Galloway.
And this is a PowerPoint on filing for EEOC complaint. So what is the EEOC? The U.S. Equal Employment Opportunity Commission is responsible for enforcing federal laws that make it illegal to discriminate against a job applicant or employee because of the person's race, color, religion, sex, including pregnancy, gender identity, and sexual orientation, national origin, age 40 or older, and disability or genetic information.
Possible laws violated by the employer. Title VII of the Civil Rights Act of 1964. She was discriminated against on the basis of her race, color, national origin, and religion.
Deadline for filing a complaint. In general, you need to file a charge within 180 calendar days from the date the discrimination took place. The 180-day calendar date filing deadline is extended to 300 calendar days if a state or local agency enforces a law that prohibits employment discrimination on the same basis. Federal employees and job applicants have a different complaint process and generally must contact an agency EEO counselor within 45 days. Regardless of how much time you have to file, it is best to file as soon as you have decided that is what you would like to do.
So for the draft, it's on a separate document. did it on the website, and it wouldn't let us, take that information. We had to submit it. So that's why.
So you should have included that into your PowerPoint presentation, or you could have created a PDF where you had the PowerPoint presentation first, and then you copied that document on top of that. All right, next. I'm sorry. Is there? You don't have anything else?
No, I'm gonna send you a separate.
link.
You want to send you a separate document of the draft.
Okay, let me ask then. What was the deadline based upon the facts for when this applicant or when this party had to submit their information into the EEOC?
Well, from what's stated is the within 180 days from the discrimination that took place.
So when did the discrimination take place?
Talking about with the lady in the story, that took place January 21st, 2017.
When was she terminated?
She was terminated officially February 1st.
So that's when the action took place. So when was her deadline?
February 1st.
They gave what, 10 days? It was 10 days. 10 days before.
The action took place when she was terminated, right? I mean, that's one action that took place when she was terminated, but there were some other actions that took place earlier, right?
Right. So
But in the context of the one that she was reporting, which is the termination. So when was she required to complete that by?
180 days. From
So what was the date?
So 180 days.
You have to compute it. All right, next group.
My name is David Ocean.
Ocean Willis, Beyonce Coach. Okay, so first of all, we started with 3 questions, which was question 1 was, I feel as though there's no valid claim for Ms. Long being racially discriminated against due to, in my opinion, there was lack of substantial amount of documented evidence in support of the claim, even though she had not been provided. She had not provided an example of an incident with another nurse, but there was no documentation of reprimanding that nurse for the incident. Also, the fact there's little to no ethnic diversity in the upper management. There's various countless examples of similar workplace demographics. This one, originally I thought that the date was 60 days after that you had to apply for the EEOC, but since it is 180 days, the last possible day would be July 31st, 2017 would be her last possible date to apply for submit her EEOC application. That'll be 180 days after the fact that it did happen. So, maybe right here, let's be close.
The U.S. Equal Employment Opportunity Commission is responsible for enforcing federal laws that make it illegal to discriminate against a job applicant or employee because of the person's race, color, religion, sex, and national origin, age, disability, or the national race. It is also illegal to discriminate against a person because the person complaining about discrimination filed a charge of discrimination or participated in an employment discrimination investigation or lawsuit.
So there's not many different ways, but still following up the guidelines that was shown online. The 10 template that you gave us. So I just basically wrote down, of course, the name, and I put over the EEOC, and like the requirements was basically you write down the events or the issues that you had while you was in the company. But when I went online, it shows like a complete application. It shows the description, the rates, and exactly the way you should fill it out when you submit it. However, I just went over some issues that I seen in the story that we read online. And of course, you have to submit your name and the date of the complaint. And that's basically all it is.
What was the last sentence in that? Read the last sentence in that document.
On multiple occasions, I was not notified. It was an incorrect sentence.
All right. So how can you extend it from 180 days to 300 days?
Wait, hold on.
All right, I'm sorry, we gotta go. Next group.
How can I do both? I don't know. Do you want me to end this?
Give it to somebody else when they can afford you. Then you can, but that's what happens once that's done before. All right, can you give it to Mr. Tucker something? All right, next week.
Public and EEOC complaint. I am Shoshana Green. I'm Tiana Kenny.
Austin Parks.
The violation was Title VII of the Civil Rights Act of 1964, also known as Title something.
Title VII, before we get to this, Title VII covers discrimination based on gender, color, national origin, age, also retaliation for being discriminated against.
The deadline for filing a complaint, a person has 180 calendar days to file a charge. However, it can be extended to 300 calendar days if a state or local agency enforces a law that prohibits discrimination.
Filing a complaint, so this is the first part. You need your information and then you need your information as well. So it'll be address, email address, phone number.
What was the employee's name?
The employee. Oh, it was just the first name. It was only the first name, but I added a last name because.
Well, I thought her name was Miss Salam.
That's her.
That was her.
Oh, y'all probably thought it was her first name.
Oh, I
guess
that
it
was
her
just
last
her
name.
first name.
Yeah, I thought that was just her
Yeah.
first name too.
I know
So we
somebody
just
named
added
Simone.
All right, no problem. Go ahead.
the last name too.
The number of employees employed at the university and the hospitals, it was 3,900. And then the description of the actions that was.
Basically, the termination date was February 1st, 2017, based on some hospital patient care rule. However, I, being the person, believe that it was discriminated against because of my race, nationality, or religion.
We believe that discriminatory actions took place when we were charged with a violation of H.R. 100, and it took place on January 9th. The charge from the alleged incident on December 18, 2016 allegedly violated Section H Rule 100. The report was written by Ms. Richards against Ms. Salam because another UMBH staff member said Ms. Salam took a 2-hour break to pray when actually it was only 30 minutes. And they claimed that she put her patients in danger during that time.
Yeah. And the last part of it.
why would you believe you were discriminated against? This disciplinary action report read by Ms. Richards against Ms. Salon because another University Mental Hospital staff said the break was longer than what it actually was.
And then we put our signature to.
Okay, so the discriminatory action took place when?
On February 1st, when the action was her being terminated.
Right, but you mentioned some other incidences in terms of the, even when she was,
Well, the final.
That was the actual
That was when
termination.
she
That's,
brought it to her
those were
attention.
others.
Like when they accused her of something and then she was terminated. On
So-
the last day.
so my question is like when she was written up for those incidences that you mentioned, that's a separate discriminatory act, right? Each action can constitute a discriminatory act, so she could have actually filed an EEOC complaint before, right?
Yes.
Right. Great. Next group. Can somebody get the time? What's on?
Just give us a moment.
Hit the press push button.
Hundred and Honor, and to filing the EEOC complaint. So the laws violated by Ms. Salem was Title 7 of the Civil Rights Act.
Title VII prohibits discrimination against employees based on race, color, national origin, and religion. Mrs. Salem violated on race, color, national origin, and religion.
Ms. Salem?
Okay, according to EEOC.com, the deadline for filing a complaint to the EEOC is 180 calendar days from when the charge took place. The 180 calendar day filing deadline is extended to 300 calendar days if a state or local agency enforces a law that prohibits employment discrimination on the same basis.
And Ms. Salem was terminated on February 1st, and so 180 calendar days from then was the deadline, which would have been on July 31st, but she filed a complaint before then.
And this is what the EEOC charge draft would look like. So you have the information of Mrs. Salem herself, the filing charge against it, and then her complaint with the several days she was listed, fall 2016, and then after that, and then June 1st, 2014.
So, it said that, and it could be extended by, from 180 to 300. Practically, how could that have happened? What's the agency that the speaker who was here last Friday, what was his agency called? HRC. And so, practically speaking, how would that agency play into this question that was posed?
Well, they have to investigate further, and it can take up to 180 to 300 calendar days. So when he broke it down to us, he said it may be some things they have to investigate, and it's not going to just take 180 days.
So, what this means, that's in your document. It says normally it's 180 days. What would that have been? What would have been the date?
July 31st.
July 31st, right? 180 days is what? How many months? What?
30.
Yeah.
6 months, right? So 6 months from February 1st is what?
July 31st.
6 months from the 7th, right? Okay. So July. So if it was filed on February, right? 1st. 6 months from February 1st is what? No, 6 months from.
That's all. February.
February is month 2, right? So 6 months plus month 2 is August 1st, right?
Yeah.
Yes.
Yes.
Now there's some days that are missing because of the fact that February is a right.
Yeah.
But between those 2 days, but the second is that if it was gone, how do you go from again the filing deadline of July 31st or August 1st to 300 calendar days? 300 calendar days would be what? How many months is 300 calendar day? Huh? How many months is it? How many months is 300 calendar day? What?
10.
No, not 12.
It's 10. 10, guys. 10. 10.
10 months. And how do you go from 6 months to 10 months? How do you get that extra 4 months?
If the state or local agency enforces a law that.
So what does that mean?
So like,
Yeah.
I guess depending on what state you live
So in the state of Maryland, what does that mean?
We have
that she can.
What does that mean? What specific? What would the state have to have done? If the state or the county government passed a law similar to the laws, to the EEOC law, particularly Title VII of the 1964 Civil Rights Act, if they passed a law that extends that right, or not just extends the right, but if it's similar to that, then that will extend so that filing deadline. So under again the filing deadline for the federal rights, it's only 180 days. But if the state law also enforces it, then you get the next additional 4 months. So most states, many states, have passed laws that are similar. For example, in the state of Maryland, there's a Maryland Human Rights Statute, and in Prince George's County, there's a Prince George's County Human Rights Statute. So that means that they can file, they don't have, again, 6 months, but they have 10 months to file. All right? That's a key question. All right. So I'll go ahead and give everybody groups. I don't know if all of you should hear, or should not hear. But for your group, I'll go ahead, since you guys are here. We gave you guys a team appearance. You were the only team that everybody was dressed in business attire. So we gave you 100% for that.
What?
Wait,
we get a whole grade for that instead of the people that actually dressed up.
Pardon me?
Like the
yeah.
So the substance of your presentation was solid, but you know there were some key things that were missing, specifically some of the stuff that we discussed in the last point. And also, you had the lady's name, you mispronounced it. It was Miss Salon, Miss Sailor. But nevertheless, we gave you a 90 for that. Your group member, everybody in your group participated. Not only participated, they even participated in the Q&A.
which was not uniform across the board in other groups. We gave you guys a 95 for that. Your PowerPoint presentation was one of the best. We gave you a 90 for that. You missed some of the key information in terms of the deadlines, which